cheaping zombies from coming in here, distracting me basically. So if I get distracted, I'll try to ignore the trolls who are very annoying. So this beef is with the Constitution. So periodically I listen to a few individuals in the YouTube streets, and then we basically do an overview. I'm not going to call this a brief overview because this Chuck Grassley is 10 pages. So a variety of subject matters are going to be discussed. This individual is speaking about legalities and law and stuff like that or whatever. So I'll begin by stating, and I'm going to be reading from this. And this was written July 14, 2022. Caller stated his ex lives in Wisconsin and he relocated to the state of Texas. So he indicated that he had a court order and the relocation agreement was made between the two, but it was verbal. So hold on, let me stop. It's a one-eyed Cyclops. Why come I'm always rhyming? It's a one-eyed Cyclops in the YouTube streets who said he is going to school, quote unquote, for criminal justice. I think some type of online. And I'm not dissing all online schools if you attend a major university. Okay, so let me continue. I just wanted to inject that into the statement. Prior to relocating, he could have petitioned a court in Wisconsin, and the two could have requested a modification in regards to parental relocation, which would have been signed by a real judge upon both parties' agreements. Keep in mind, dependent on the state, verbiage can vary when it comes to any given types of petitions, basically. So that's why individuals are going back and forth. Obviously, it's all per usual, darlings, in the YouTube streets, because they're always saying, no, it's called this, it's called that. Depending on the state, the petitions are going to be named. It's going to use different verbiage on the face of the forms. So I don't understand what the unnecessary school, you know what I'm saying, beef is about. And that's common sense. Just like individuals have different states have different state laws or whatever, but when they're uniform, darlings, then you have to abide by certain types of regulations. So the caller indicated the other parent changed their mind and reneged on a verbal agreement, which was made outside of the court. This is generally the atypical for generally black females, and we know that other groups do it, but as per usual, predominantly black people do it. Okay, the call in. This is not everyone. This is not a generalization. I would like to make that disclaimer. The caller mentioned the other part, the parent receives aid, which is 9 times out of 10 why she changed her mind, sir. Especially if she doesn't have additional minors who receive aid under her care. Caller mentioned the other parent cut the card off. When she gave him the card, she cut it off, so he couldn't feed the kids when he relocated them to Wisconsin. She probably changed the pin because she did not report the card stolen. Otherwise, it opens up another arena in relation to making false statements and claims. So that would be fraud. It's a different type of fraud, but it falls underneath false claims. In the past, and probably still presently, individuals like crackheads or homeless people would give their cars to others, generally like dope dealers. We're going to keep it 100, and would report the car as stolen. Depending on the state, policies are implemented, which means if individuals repeatedly report cars stolen, their cases can be flagged. Not quite sure how many times individuals have until their cases are flagged because it varies from state to state. Then again, and that is illegal, basically. Caller mentioned children are 11 and 14 years of age. In the state of Texas, more leeway is given for children to speak for themselves via verbal or written testimony. So that's how laws are being modernized to level the playing fields. The caller can petition a court if and when they meet required residency. The receiving state would be Texas and sending state would be Wisconsin in this case, based upon this case status, and not the entire case. This is just a brief based upon what the individuals was communicating in the interview. Via interstate processes, any and all orders would be forwarded to ensure both parties have fair access to real courts without hindrance and or interference when it comes to due process. Upon forwarding, give me 1 second. Okay, I made a clerical typo. Upon forwarding the petition, the court generally reviews any out of state orders when and if jurisdictions are met, basically. Reviewing out of state orders serves as a buffer to ensure controlling orders and or laws are preserved and stay intact, which subsequently it attempts to ensure neither party's rights are being trampled or violated. Interstate cases are sensitive cases and can take longer to process due to various type of legalities. I'm sorry, I say legal legalities. Interstate cases are sensitive and they're not generally worked by regular case workers, basically, because it involves stuff that like generally attorneys generals are supposed to know and stuff like that. So a different level of caseworker are assigned those type of sensitive cases because you have to know policy, you have to know state laws, rules, regulations, guidelines, and administration. So then there's also a checklist that individuals go by to ensure that all the criteria have been met. If and when individuals cannot afford counsel, i.e. representation, they can request assistance via Attorney General's office. Depending on the case type, sometimes a $25 fee is applicable. Whether or not it has increased, I'm not sure. If the case type is non-AFDC, non-assistance, a fee is applicable, and if it's AFDC assistance, a fee is non-applicable. AGs do not represent neither party and are supposed to represent the best interest of child and or children, and individuals can also attempt pro se, basically. So the Attorney General's office do not represent you. I know a lot of state workers have been trying to skirt and circumvent laws, but AGs do not represent the parties at no particular time. And they're not supposed to operate based upon feelings, and we're giving it, throwing that dagger to the state of Louisiana, Washington State, and Hinesville, Georgia, basically. But in this particular mock situation, it's a real event, but I don't have access to the interviewee. He's speaking about the state of Wisconsin because he relocated to the state of Texas. If parents do not have legal custody, nothing prevents either party from moving out of state with child and or children. It's always best to check to research your state laws, basically. Keep in mind whether or not legal custody exists, there is such a thing called parental kidnap. And that's when individuals have to use parent locators and other type of tools in order to locate child and or children when they come up missing. So they can be cited as a missing person until a child well check is performed or conducted. If and when this occurs, it gives the other party, no matter the gender, to request a well child checkup in an effort to search and locate child and or children. If child and or children are not in imminent danger and are not being abused, authorities generally encourage the other party to obtain a real court order via petitioning the real courts. If child and or children are abused, it sets the grounds for CPS to intervene. If and when abuse is founded, only the party who abused the child and or children should have to engage in real services. Generally, the other party must prove paternity prior to being relinquished to the non-abusing, prior to the child and or children being relinquished to the non-abusing party, no matter the gender. See how we don't have to inject feminist narratives. We don't have to inject feelings, and we also put the weight on both individuals, no matter the gender, because you have social media gender wars going on, which are very low vibrational. And I'm just trying to see how do you get to real solutions, positive solutions, that is, that does not waste state workers' time who are competent, and doesn't waste lawmakers' times, and doesn't waste senators' times, and doesn't waste the court's time, basically, i.e., and then waste the taxpayers' time, because different types of funding funds different types of programs and stuff like that. So included in the state budget. So the CP finds other individuals to carry out. Oh, give me 1 second, because I'm thinking, too bad we can't pause on YouTube. Give me 1 second. Okay, I think this is the second page. I forgot the number of the pages, you guys. In any event, when individuals relocate, it is always a good idea to notify and petition the court. So that was his first error or mistake, basically. He should have petitioned the court, especially in situations, and then he would have asked for a modification, especially in situation in relation to the cost of living, because each state uses different calculations as per not his attorney, but the individual he was speaking to stated. So that's correct. If the cost of living is higher in one state and lower in the next state, can be beneficial for real NCPs, no matter the gender. No matter the gender is cited because it's rare, but is becoming more common for NCPs to be birth mothers of child and or children. Whether or not they actually pay child support, or if laws are strictly enforced against females like they are against men, as predominantly black men, that's a whole nother entire story. Most of the time, CPS um, do not generally, not most of the time, CPs, I'm sorry, who are males or men, do not generally press for child support because they can generally support the child and or children, and sometimes they may feel a sense of guilt, so they prefer to opt out of actual enforcement. This suggests males are not as petty or revengeful as females, basically. So a lot of states are getting hip, and so are judges are getting hip, and they've been getting hip for about 10 years now. All the back and forth and open a case, drop a case, open case, drop a case, call a case, because they keep going back, break up, make up, and the court doesn't have time, and neither does the state and or federal budgets. Y'all ever hear females feel as though it's bragging rights? And when I say bragging rights, when they say they can still sleep with their child's birth father, males will generally exchange sex in return to maintain access to their biological offsprings. Males who are CPs do not generally use this method of blackmail. If males do not agree to continue sexual relationships, they can be blackmailed, or they are prevented from having a relationship with their child and or children, which is totally disgusting. So I don't know if this individual is going to go through that or whatever, but he can expect anything at this point in time and space, which is why his first step was he should have petitioned the court in Wisconsin as it pertains to a modification. Okay, let's see. And keeping in mind, any modifications must you still have to go before a judge or individuals who are officers of the court, and their information has to be verified, and both parties have to be present remotely or via conference call. This is a waste of okay, let me continue. Keep it in mind, anytime any individual petition a court, stick to the facts and evidence, because judges hear so many cases and they do not have time to hear petty stuff or minute disagreements. This is a waste of taxpayers' dollars, funding, and a waste of officers of the court's time as well. Refrain from constantly petitioning a court unless there are extreme changes in circumstances or emergencies. Do not stretch the truth nor over exaggerate, because false testimony, whether written or verbal, is perjury. And it's punishable by law. Refrain from sabotaging your situational cases, basically. So that's the not advice, but that's a good statement that could be used to conclude that individuals not to conclude it, but that could be a good statement to end right there, basically. So let me continue. Y'all mock attorney, that's y'all mock bald head attorney. He's not your attorney, but this is like a mock situation, but it happens to be a real event. You know how you watch the movies on Lifetime and they say based upon true events? Y'all mock attorney stated no lights is an emergency, and that was false. Perhaps he has been perhaps he was using this as rhetoric. I don't know. No lights does not fit the criteria for CA in child abuse and or neglect, even though a lot of competent state agencies are moving away from the term neglect, basically. And that's why that's how services can be offered rather than removing child from homes. So if and when mandated reporters such as neighbors or others who are considered mandated reporters, if they report any type of incidents, cases are not completed and or open fully, FCA is unfounded. As it relates to offering individual services, no matter the gender, this phase is referred to as the preliminary intervention interventions phase, and generally coded as occurrences and or events. Generally, any types of assessments, occurrences, interventions, and or events are supposed to be properly tracked and coded, basically. So, okay, it's a good idea. I don't know. I know for sure a few states are not. They're using multiple client ID numbers. Individuals are generally supposed to have only one client ID number throughout their entire lifetime of any type of given case, basically. And you're not supposed to manipulate and change it. Normally, the system will let you know whether or not a case number has to be changed. But technology has evolved, and 9 times out of 10, you don't have to interfere with that type of with those type of operations manually, basically. So this is encoding is imperative, especially if and when cases meet criteria for CA. Many states have phased away, as I've stated, from using the word neglect, because if individuals simply need parenting classes or other type of services extended to them, it's more cost efficient for state and or federal departments and agencies, and it also reduces unnecessary burden, i.e. workloads on state workers who are competent when proper services are extended versus child and or children being removed from homes based upon financial situational events such as no running water or no lights. Council. Individuals need to be mindful when requesting voluntary services of any given kind because services are not all generally free. In a few states, individuals have been defrauding state agencies or acting as though they are in need of real services when they are not. Individuals basically register or sign up for voluntary placement VPA and basically attempt to misuse and abuse services and or programs as if caseworkers or extended daycare providers. So they're thinking that state workers or daycare or they're temporary or permanent daycares, and they're not. This is illegal and it's also punishable under laws. Once again, when and if any given types of services are requested prior to services being rendered, cases must go through proper verification and authorization processes. So let's get into rare types of waste, fraud, and or abuse. Mr. Chuck Grassley. Many males are not familiar with how various types of fraud works and or operates, especially when they do not live in the same household as CPs, and if males are the biological or and if males are the let me repeat that. Many males are not familiar how various types of fraud works and or operates, especially when they do not live in the same household as the CPs when they are real CPs on its face. And when in F males or not the biological father. So it's normally quote unquote a step parent. Let's take a moment to review rare situations. CP lives with a partner who is not the biological father of the child and children. And this individual that's relocated from Wisconsin to Texas, he could take notes. He's not here to take notes though, and he can't see this channel. Cause if anything broke out or whatever, and by him being away or whatever, yeah, they would have to contact him. But let's say she ended up moving with another partner or whatever. It's a lot of red flags that can, prevention. He needs to take the proper protocols to protect his best interests and also the interests of the child and or children, which are 2 minors, 11 and 14. So let's continue. And this is not his situation. We're just integrating and injecting just possible scenarios. CP discovers holes or gaps in the system. CP finds out their state administers voluntary placement agreements known as VPAs. And the verbiage varies from state to state. CP registers child and or children for unauthorized services. CP finds other individuals to carry out acts to knowingly and intentionally to defraud programs. CP can use, and programs are subsidized, and you also have unsubsidized programs which were being targeted, such as real private health insurance. CP can use relatives, friends, partners who are not biological fathers of children or child to carry out acts to defraud state programs, state and federally funded programs, which is also funded by the American payers' tax dollars, and they're also consumers. CP provides false information to state agencies and gets approved for state-based services without proper assessments, verification, and or authorization. So in this case, the guy mentioned that the individual, the child's mother in Wisconsin was receiving some type of public assistance. So there are cases where intentional program violations occur, and CPs would have to pay if they provide false information or testimony to state agencies or courts. They can have to be. They can have to be. They cannot. Not only can they be charged, but if they work out certain types of administrative agreements to prevent charges being filed, individuals, males, No matter if you're married or unmarried, you need to watch out for stuff. Married or separate, you need to watch. Married or single, you need to watch out for things like that. Because what a lot of state agencies have been doing, and not all of them, competent ones don't do this. Let's say she's in Wisconsin. Let's say she does something with that card, or she does something to where she has to pay the state back a portion of money. So when this happens, then they'll pull money, pull it from child support, and she wouldn't receive that child support money. Instead, it'll go automatically to the state. So individuals who are incompetent state workers, Washington State, Hinesville, Georgia, Louisiana, the liberal side that is, they have been finding ways to sit up there and calculate fraud and mask it as IVD, as child support, and that's illegal, and it's also unethical, and it goes against agencies' rules, state laws, federal regulations, guidelines, administration, and all of that other stuff underneath the good sun. Let me continue. CPs generally, let me repeat that one more time. CP provides false or misleading information to state agencies and gets approved for state-based services without proper assessments, verification, and or authorization. CPs generally use maternal grandparents or other types of relatives or friends to assist them in the commission of carrying out crimes to defraud state-based and or federally funded programs. This is not his case, but it could be. You know, people like, oh, I'm gonna let the grandma have the kids. Grandma had the kids. Then everybody's getting aid for the same kids. That's illegal. Washington State. I'm not speaking to Wisconsin because they're not on the radar for waste, fraud, and abuse. And this is the as for individuals who receive certain type of assistance, take notice. CP lists individuals who are third parties as caretakers, and there is a process that you have to go through, whether a civil or real legal processes. And when we say civil, we're talking about administrative, but you still have to see some type of officer of some type of competent court. Those still have physical custody of child and children. Most often they will, let me repeat that, CP lists individuals as caretakers, though they still have physical custody, control, custody, and care of child and children. Most often they will say, oh, a friend or a maternal grandparent or custodians, keeping in mind that such arrangements require real court activity for third-party custody when events are legitimate and real on its face. So guys have to be very careful. And females too, if they're the NCP, you have to be careful, period. CP and caretaker both receive various types of public assistance from various agencies underneath the fictitious guise of social services, IVA, IVB, and or IVE, and I put that in tough air quotes. When and if any given types of case types are created manually, which is unethical, even using fake paperwork and supporting documents, it can trigger automatic alerts to IVD departments, real IVD departments and units, unfortunately. It's not supposed to, because there's supposed to be some type of IT and other type of quality assurance and barriers set up to detect and deter and combat waste, fraud, and abuse. Generally, any given case types must always be authorized. When they are not properly reviewed, individuals who engage in acts to deceive programs can cause fictitious IVD cases to be created. And this can affect civilians and or members of the Department of Defense, basically. CPs are not aware when they pretend they need any given types of services and list third parties as custodians or caretakers. They then become NCPs of any and all accounts, aka fraudulent case identifiers and real events. They cause to be created, which are not authentic case numbers, which is why they are dubbed case identifiers. Any and all financial amounts which are received by multiple individuals which overlaps under circumstances, multiple individuals apply for and receive aid for the exact same honors, which is unethical and illegal. This triggers IPV, aka intentional program violations in relation to multiple individuals who receive unauthorized services and or aid. In a sense, CPs and NCPs who requested unauthorized services and engaged in deception or fraud become the parties who are responsible for reimbursing state agencies. Keeping in mind, people find fancy ways to send fake documents to TSP, Department of Defense. As stated, what has been seen is bad acting. State employees knowingly assist clients to deceive programs rather than reassigning fraud case identifiers to proper investigative units such as OFR, Washington State Take Notice, Office of Fraud Recovery, PSO, payment service only. Unethical when when it's unauthorized. It prevents and hinders individuals from having access to real courts, basically. They attempt to cover their tracks and cover up crimes via PSO, payment services only processes. And they should be using OFR, Office of Fraud and Recovery, in their state, Washington State Take Notice. There are various criminal ways to make IVD cases appear legitimate, especially when case types are miscoded as NA or blank, which is unethical and illegal, or when multiple clients have multiple overlapping client ID numbers or case identifiers in which the case events and or all occurrences do not all align with agencies' policies, rules, procedures, administration, and federal regulations, as well as UIFSA. When case types are not IVD, it can be falsely presented and misrepresented as quote-unquote IVD. This is unethical and illegal and pose substantive and procedural concerns, i.e. errors. Those are listed as errors, substantive and procedural errors. Let's continue, and that's judiciary concerns. So Senate Judiciary, they can take notice, but this is my deep red states know how to handle career criminals and felons who are habitual law breakers. Let's continue. When enough case types are miscoded, it can create situations which subsequently leads to case types being placed in wrong dockets, basically. So they have found ways to trick the courts and the judges. Sneaky tactics are not ethical nor legal and pose threats to due process and fair access to real courts, which in turn pose civil rights concerns and threats to human rights. Unethical tactics also make it to the court. No activities have taken place which can result in premature DWOP. Keep in mind, individuals who attempt to engage in unethical and unlawful practices are not always attorney generals. Rather, they're caseworkers. So they're open stepping their boundaries and authorities, basically, because they're operating as though they are judges and or attorney generals, which is unethical and illegal. And they're not authorized to do that. Give me 1 second, because I think I have made all right, so individuals be using ignorance of the law should be no excuse in the wrong context sometimes. Ignorance of the law should be no excuse, meaning if you intentionally and knowing like break a law or whatever, ignorance still shall be no excuse. No excuses shall be made. State workers receive limited immunity, so it kind of it gives them leeway to, you know what I'm saying, to kind of prevent them from facing criminal charges. But the immunity is limited. So if you knowingly intentionally engage in the commission of crimes and you assist clients and you tell them about stuff that they're not even supposed to know, that's illegal and unethical and it's punishable underneath law. Keeping in mind, real efforts in relation to proper service must occur and isn't up for debate, okay? And that's when we get into real legal. One eye Cyclops and the YouTube streets, beef YouTube sector, take notice, sir. Any and all administrative operations must be in accordance to agencies' rules, policies, laws, UIFSA, and federal regulations. Where are the criminal justice majors? Where they at? And where are the fake attorneys at? You need to go back to law school. Not you, sir. And we're talking about the up and coming, the ones coming behind us. And we're also speaking to the ones that came before us, who are competent, that is. We don't negotiate with domestic terrorists. Unauthorized administrative defaults cannot be used as a consent order. That's what states have been doing. Washington State, Louisiana, and Huntsville, Georgia, take notice. Prohibited, as any written agreements must be properly reviewed by judges or competent officers of the courts. 29 minutes. It has been found that bad state actors prematurely execute erroneous quote-unquote defaults and subsequently execute fictitious wage assignments known as unauthorized garnishments. thus misusing governmental forms, whether state-based forms or interstate OMB forms, which always must bear the control numbers on its face. If forms do not bear a real control number, or if a control number is altered and or manipulated in any given fashion, it makes it null and void. Take notice, General Motors and subsidiaries, i.e. contractors for General Motors, corporate office. Show cause General Motors, Washington State, DSHS, Hinesville, Georgia, Constance Jones, as pertains to real court order signed by a real judge. Take notice, Louisiana. Louisiana, think because they closed. You can return a $10,000 or $20,000, or we can keep the ball rolling. Lynette Florent, Jefferson Parish Juvenile Court, tampering with evidence and governmental forms, engaging in personal identifiable information misuse and abuse, as well as social security numbers. PII can fall underneath a range of different things. Different things can fall underneath the range of PII, personal identifiable information. Yolanda Smith. No, individuals don't want to have any type of thing. It wasn't even COVID. This lady sent up there, why are you, once again, because we asked her in 2014, using some type of non-authorized means of communications. Pick up your office phone. But really, not really. We're moving forward. I was going to say moving on. See, y'all, that's why I can't go to the Capitol. I'll be sitting up there singing every time I sit up there and see these tricks. It has been founded, I already stated that, I'm sorry, site calls and or claim RCW 26.26A, Washington State DSHS. Paternity corrections can only be made when it has been proven either by DNA test or a order that the man named on the BC birth certificate for you newbies coming behind us is not the natural AK biological father. Take notice, Department of Health. And your attorney generals can take notice too, Karen Calhoun. Respectfully, because she didn't know what the hell was going on. She didn't see the other fake papers. She's in a loop, and she drafted a petition and it was rejected because they contained errors, basically. So we're going to use a different type of agencies. Agencies it's supposed to be streamlined. So any activity underneath IVA, IVB, fictitious IVE, it must also connect to IVD, basically. Otherwise, you hinder due process and fair access to real courts. The administrative IWO, null and void on its face because false information and misleading information was inputted into various type of databases. Individuals executed a erroneous decree and submitted false information to TSP and other state agencies, as well as the IRS. Take notice. IRS is still working on kinks or whatever, so they're trying to figure it's going to take them because the retired people retiring, and that's why training is important. Let me continue. For instances, if males subjected to unnecessary issues, basically relinquish parental rights. That's an option for males and or females. Relinquish your parental rights if you don't want to be financially responsible. Responsible basically, and stop wasting courts' times, agencies, resources who are competent, and stop wasting the taxpayers' time. So relinquish parental rights if you are being prevented from having visitation, but keep in mind, you know what I'm saying, individuals don't understand what contempt is. You can be in contempt if you violate any type of real court orders, which no court orders are existent, General Motors and its subsidiaries. You tell that lady. I just came to face with a lady who stated that she worked for the legal department. But my legal department, ma'am, you can come up to the table, whatever, and we are ready. Respectfully. And all I want to do is speak jargon and laws, basically, not feelings. If and when a real court order exists, and if any real back child support is owed, which is not, once the BCs have been paid in full. BCS have been paid in full. Current support is non-applicable, so males do have the option, males or men have the option to relinquish parental rights. If individuals like incompetent state workers are going to team up with their clients, teach them how to break state laws, federal rules and regulations, you just remember that you have options, no matter the gender. We're not going to put man, black man versus black, no matter the gender. And that's a message for the Black Beef YouTube sector so that I can carry on and get up out of our way because we have business to take care of. And a lot of people are not bothered with contempt. Even though it's kind of bullshit because if all you just follow and abide by the court order. If and when a real court order exists, oh, I'm sorry, I read that. And vice versa, no matter the sex, is what I wanted to say. This may appear as extreme, but it beats having to waste money. If and when you are below poverty level or waste court's time when court have to be repeatedly petitioned unnecessarily. Darlings, we're speaking to both genders. According to Washington state statutes, abandonment occurs when a parent or guardian physically abandon his or her child and or children and leave the child and or children without food, water, and or shelter. Andrea Williams, Malcolm Elijah Jones, Tia Soller, Tia Bryant, Tia Shaw, Tia Saw, SYAW, Tia Thomas. Apply SERA, Department of Defense. And TSP need to understand that if they don't receive a real court order, you are not to relinquish any types of monies. DFAS as well, any types of monies to outside agencies. Any agency outside of the Department of Defense is an outside agency. Now, we're supposed to be federal partners. However, when you have individuals like Felita Hannah Poole of Leesville, Louisiana, individuals who know the clients, they are considered enemies of the state. You can sit this one out, mainstream, who are competent, basically. And let me continue. What happens when CPs abandon their children? CPs become the NCPs. Keep in mind when CPs and biological fathers engage in paternity fraud and or welfare paternity fraud and or cross state lines or execute invalid, erroneous, fictitious Title 13 guardianship schemes, real third-party petitions and orders must be legitimate on its face and signed by a real judge, which makes all activities null and void. When they are legitimate on its face, biological fathers and birth mothers are the only individuals who can voluntarily authorize third-party guardianship. Non-biological males cannot legally authorize third-party custody or voluntary placement. Presumption of paternity not only should be repealed, but it is being refuted and rebutted, basically. In any event, any and all criteria must be met before individuals, incompetent state workers, can even stand on the grounds as it pertains to paternity of presumption. Paternity based upon presumption. Non-related males cannot legally authorize any type of adoptions. Keeping in mind, there are no real adoptions, you guys. We're just using this verbiage so that Chuck Grassley and individuals at Ways and Means can understand and comprehend the severity of these collateral attacks and threats against the United States government and state and federally funded programs. Federal funded programs. My bad. Had to get it out. Paternity of presumption can only be claimed if and any all criteria have been met. And I yield back to your Attorney Generals, Karen Calhoun, in fraud case that it was not met. Yield back to Washington State AGs. And don't come with the bullshit. Don't come waving your titles and shit. You come being impartial. That's how they're supposed to come. No shade, Karen. Now yield to also the senator of Washington State. What's her name? Patty Murphy or something like that. Individuals, when CPs intentionally falsify birth questionnaires and also forge or cause to have fake electronic signatures added to birth records, the operations are illegal, null, and void. Yield to Army Madigan. The operations aren't any different from robo-signatures, which have been seen in other larger financial crimes due to the big banks and any other given types of forgery and schemes, which does not always have to occur via actual writing signatures. Individuals occasionally speak about divorce because, there are divorce attorneys in these YouTube streets. Have individuals ever seen a fake divorce decree, or have they ever seen documents which appear as legitimate in the form of a divorce decree, and that information is sent to different departments and or hello TSP? Have you ever seen CPs cite themselves as NCPs on child support for the amount of 0.00 on fictitious divorce decrees? And then it magically turns into 800 and thousands and thousands, running that calculations running up to $1 million. Washington DSHS, waste, fraud, and abuse on its face. I yield back to the departments or their spokespersons. Keeping them on payment numbers or whatever, these are just some records. Thousands of records exist, Mr. Chuck Grassley. We're not going to waste DC's time with this, but individuals at the federal agents departments can still send out their memos to Washington State, Louisiana, and Hinesville, Georgia, and encourage them to right their wrongs. If this was the Reagan administration, these agencies would have been sanctioned. So we don't want to talk Russia, Russia, Russia. Chuck Grassley, this is how I look on his face, sir. And individuals know that the case numbers are identical. Just ignore this right here. That's fictitious. It's a miscode. These amounts are higher amounts. So that's why we say money when wire fraud occurs, money laundering. Money laundering is the aftermath. Make it make sense. So let's go here. These amounts about $80,000 to $90,000. Notice that the case payment numbers, these in this 10 to 20 client IDs and case identifiers, that's illegal. Washington State, Louisiana, Hinesville, Georgia. You're not supposed to be opening up multiple cases in 3 different states. Take notice. Make it make sense. Make it make sense. So this is what individuals do when they cannot legally obtain a real court order signed by a real judge. 3791. And keep in mind, this information does not match the information in SIMS and or ACES and or FAM link. Hello, app. Yeah, the serious red flag is the case type noted as NA, because if you see these two, and these are just a few individuals, there's a lot of individuals that are involved. Their names are not always on his face, but appear in other fraudulent documents, which we call big dirty data. Case type NA, illegal. A 25 fee would have to apply, and that information can be seen, and it will be in Louisiana's files. The $25. Yeah. So congratulations to the judge, because she was thrown for a fucking loop, because she didn't know what the fuck was going on, and on the record had to cease at that time and space. She didn't know what was going on. Individuals handed her fake information. So she reduced it from $200 to $50 or $60 until they could sort it out. And then individuals relocated. So now we're still on the roll. And we told them in 2014 they can right their wrongs. They could have written their wrongs right then and there. But they chose to assist clients who never touched state in Louisiana at all. Basically, no minors lived in the state of Louisiana. No parties lived in the state of Louisiana in or at that time. This amount is higher. This amount is higher. And that's how we know that other cases exist. Because why? Because then you cross-reference. This is what you have to do. That's why we don't want competent state workers to be put underneath so unnecessary bullshit. So then they make it appear that individuals are receiving the monies. You see that? Now I've already called out the case identifiers. I'm gonna have to call back. 214-4748, 210-2287. Give me 1 second. Oh, let's see. Let's go. And I know it's 175. 1750370. Of course, it's gonna say quote unquote close. This 375 comes in close proximity of $373 they cited on forms erroneously. So let's get back to the other fraudulent SIMS cases. DSHS, DCS online SIMS case number quote unquote 210-2287. 214-4748, 210-3476, 210-3719, 210-3722, 210-3726, 214-4751, 553-1015 as the fraudulent remittance number, basically. And we indicated what starts as fraud ends as such, correct? So give me 1 second. And we'll have to go back. It takes a lot of cross-referencing dirty data, basically. So let's get back to it. Sweeties. Give me 1 second. And then I'm going to pause too, you guys, because I'm about to end this and I'm going to start back. Okay. The checks forwarded. I'll see what turn is happening. Checks forwarded are not going to be canceled. They're going to be given to departments and investigative units and or authorities. I yield back to Sherry Redmond. Okay, Sherry Redmond of Washington State. DSHS, the secretary, basically. So what starts as fraud ends as such. So we got 1, 2, 3. We got this. CP. Mind you, multiple aliases were used. What starts as fraud ends as such. We're not going to waste time. We're not going to waste time. And you can also go to 214-4748 or yet another. Any and all case identifiers belong to the same individual who started the mess. Right now I'm looking for CP arrears. So that's DSHS. And you can tell by it doesn't take rocket science to see that the math isn't mathing. You got CP arrears. And I hope that's clear. You got CP arrears. We got more of it too. It bouncing between DSHS quote unquote fictitious arrears, CP arrears, Tammy. Oh, this is what welfare paternity fraud looks like, and it's keep in mind it's a whole bunch of individuals. So I'm gonna end there. I'll get back to Ways and Means though. I'll get back to Ways and Means, Health and Human Services. I'll get back to Congress. So I'll be back for whatever. We're gonna get back to a few more, and we are now on this page 1, 2, 3. So we have probably about 7 pages to go. So this is Irish Canary, and this special broadcast is brought to you by, you know what I'm saying, Independent Contractors Investigations, basically. Oh, I said that I was going to share something with you guys. I gotta let you guys know there's a special committee that has some type of opening. I'm not sure if it's for voluntary service or for actual pay, but I'll give you that information later on at the end of the day or by tomorrow morning. This is Irish Canary reporting for AI duties. I'll be back, you guys, and I hope you had a great day.